Good afternoon, everyone. My name is Alina Gilbert. I will be presenting our final webinar of 2023. Can you believe it? Oh, this is the last one. Choosing contractors, what should you be looking for? I appreciate all of you joining us. And our next webinars won't start until January. So please, the calendar's already up. You're welcome to start looking at the different topics and signing up for them if you want to. So we're going to make this one extra special, maybe, and we're going to talk about choosing contractors. Before we get started, as most of you know, we're going to go through some housekeeping items. Oh, and by the way, if there are any contractors like listening to this, I'm not trying to offend anyone with the memes, but they made me laugh, so you know, that's all I really care about. Just kidding. Okay, so right now you should be seeing on your screen the PowerPoint. It should be taking up pretty much most of the screen, and I am on the left side of your screen. On the right side, you should see a little icon that says private chat. So that's where you're going to type in questions or comments that you might have as we're going through the presentation. I typically save those for the end just to make sure we have enough time to go through all the materials, and then time permitting, we go through the questions. I think we'll have time to go through questions today, there is a lot to talk about, but I think we should get done in time to allow some question time. You will be getting 1 CMCA credit for attending this webinar. It will be automatically generated. It's going to get emailed to you, assuming you've stayed on the entire time. If for some reason you don't see it, today's Wednesday, so if you don't see it by like Friday, go ahead and shoot an email to our education coordinator, Jessa Ledesma, and that's JLEDE, S as in Sam, M as in Mary, A at altitude.law. Jessa's direct office line, if you'd rather call, is 303-991-2086. And you can also call Jessa if you're having any kind of technical difficulties, although before calling Jessa, you will see there's a little icon at the bottom with a question of, are you having a problem with your audio or visual? Click on that button first, and it takes you through a series of steps that usually resolves the problem. But if that doesn't help, then go ahead and reach out to Jessa so she can try and fix some stuff on her end of it, if there's anything she can do. And then on a final note, as you know, if you've done one of these webinars before, we do have a questionnaire that automatically pops up at the end of the presentation. We love your feedback. It doesn't have to be great. It doesn't have to be good. You can tell us everything you hated. Anything you write in there, we take very seriously. It helps us, create better programs for you as time goes on. And we definitely want to hear your feedback. So if you have a minute to fill that out, it would be most seriously appreciated. All right. So, we're going to start pretty broad, as I like to do. So before we talk about choosing contractors, and I want to acknowledge that for those of you who are community managers that are on this call or on this webinar, you look at contractors, far more than I do. You look for contractors all the time for your associations. And so I'm not purporting to know necessarily more than what you know as far as choosing contractors. I'm trying to approach it from a different perspective, which is kind of more on the legal side and things that could go wrong. So again, I fully understand that you guys do this all the time, and I completely respect and acknowledge your expertise in this area. But there are legal things to look at sometimes, and I think those are important to look at as well. Anyhow, what's a contract? I think we all inherently know what a contract is. It's a binding agreement between two or more persons or parties, that's legally enforceable, right? And who's the contractor? Well, that's the person or an entity that contracts to perform work or provide supplies. Now, what do your associations contract for? I guess the question is, what don't they contract for, right? So this is just a little sampling of what they contract for. Landscaping, legal services, management, we're all vendors, right? Essentially, insurance, pool maintenance, snow removal, construction, and probably a whole heck of a lot more. I mean, obviously, we're not going to fit everything in on this slide as far as what your associations contract for, but you guys know very well how there is an abundance of different services out there that our associations use depending on the type of community, what kind of amenities they have, etc. So there's so much. And I'm showing you this not because you don't know what associations contract for, but basically to just show how important it is for our communities to choose appropriate contractors to do the specific work they're looking for, and how it is so prevalent in the HOA world, because you're always hiring someone to do something. None of us are experts at everything, and kind of the board and the community manager, you have to find the right people to do the things that need to get done for the community, and that's never going to change. So it's very important when we talk about getting contractors and getting bids. So just very briefly, I'm going to say this once and we're going to go over this again later, but a bid is not a contract. Okay, I have so many communities in the past where the board just signs off on a bid and treats it as the contract. Well, that is the worst thing to do. And we're going to talk about why it's a horrible thing to do later on in the presentation. But I just want to distinguish between the bid and the contract. They should be two separate documents, okay? So real quick, how many bids do you get? The prevailing opinion is best practices is to do 3. Yep, and some of you are responding saying 3. Right. I know that's something CAI preaches, and I think that's considered, reasonable legally. I'm just going to talk about legally, which does not mean it's the right answer on a practical side. You're not required to get any specific number of bids, at least not in Colorado. But why do we want to get 3 bids? Well, for the most part, it's really for liability protection. If, our boards have a fiduciary obligation to act in the best interest of the association and in an informed manner. It's hard to be informed on what's best for the association if you're not doing your due diligence to figure out what's out there, right? If you're just looking at one bid, you have no idea if that's going to be considered high, low, good, bad. You just don't know. And so by comparing, you can get a better understanding and therefore hopefully make a better decision. But legally, you don't have to get 3. But please don't take this to mean you should not. Now, some contracts are for a measly amount, $500, $1,000. I'm not sure it's a good spending of your time to be getting 3 bids for things like that. But any type of a contract that is, I would probably say, over $5,000 is probably worth getting more than 1 bid on. And kind of the other thing about bids, see, I caught myself. The other thing about bids is, what do they look like? Every contractor kind of does their own bid, right? So some bids will break down the project and the work. Some bids will have specific details of what's going to happen. And I think those are all important because that's what allows the board, I think, to make an informed decision as to which contractor is going to be the best for the performance of a particular job. All right, comedic break, and then we're going to move on. Dun, dun, dun. All right. All right. We're going to go through through 10 common mistakes. That doesn't mean they're the only mistakes, but there are 10 common mistakes that associations make when retaining contractors. And I'm sure you guys should be able to what's the word I'm saying? You all understand, you've all been there, you've all done that, and you've all experienced these various types of mistakes, I am sure, by boards, and sometimes by newer managers as well. So one, cheaper's not better, or it's not always better, right? You know, the phrase "you get what you pay for," it comes from somewhere, you guys, it does. And so there's some truth to that. But ultimately, when you're comparing contracts, or your boards are comparing contracts, and one is significantly cheaper than the other one, you need to stop and ask, why is this one cheaper? How many of you have boards that will just jump at the one that's the least expensive and be like, just go with this contractor, they're the cheapest, let's just go with them? There's boards who do that. And because to them, that's really the most important thing, cost. You know, they want to manage the money of the association and keep costs down. But my question always is, why is it cheaper? Okay, so that takes us to the next slide, actually, which is comparing apples to oranges. When reviewing proposals or bids, what you want to make sure is you are comparing apples to apples, which means what the contractor is bidding on is the same as what the next contractor is bidding on. Because, for example, if you look at the first little check mark, building materials, you can have two contractors bid for the same work but with different building materials, and one of those bids is going to be a lot cheaper because they might be using cheaper building materials. So it's really important to distinguish between the various bids and to know what you're looking at and figure out why one contract proposal might be cheaper than a different one. What kind of work are they going to perform? Are they giving you specific breakdown? Are they telling you, like, for example, I keep thinking of like roof replacement contracts. So you can have a contract that just says, we're going to replace the roof. Okay, we're going to replace the roof. Or you could have a contract that says, we're going to replace the roof by doing this. We're going to remove the membrane. We're going to waterproof, you know, whatever. And it breaks it down step by step what they are bidding on. So let's say you decide to go with a cheaper one, which is the contract that just said, we're replacing the roof. Well, that might exclude certain portions that the other contract bid was covering. So maybe they don't do the waterproofing. Maybe they don't replace the membrane. Maybe they're just doing the tiles. So again, we don't really know why a proposal might be cheaper than another unless we really dig in to these proposals and figure out what the difference is, because I guarantee you they're not identical. They never are. So don't assume that the dollar amount, you know, is what you get. So a couple examples just to drive the point home. So think, for example, airline tickets. I am one of those fools where when I'm looking for airline tickets, I'm just going to look for the cheapest one. I don't care which airline it is. I just want one that's, you know, kind of is cheapest. Now, when I get that one, then all of a sudden, and I never learned my lesson, if I want to pick my seat, I got to pay extra. If I want to board first so I can have, you know, overhead luggage space, I got to pay extra. There's a million extras on there. But if I had looked at other airlines, perhaps with the more expensive tickets to the, you know, same destination, I might have noticed that those more expensive tickets include, you know, early boarding. They include a carry-on item. They include a seat choice. And ultimately, when I crunch the math, most of the time it turns out if I just paid extra up front, I would have saved money than picking the cheaper tickets and then spending additional funds to get what I needed, right? So this is exactly the same thing. It's the cheaper one, the cheaper airline ticket is not always going to be cheaper once you put in all the other things that you need to put in, and it's not always going to be the best. So make sure you're looking at and comparing your bids and your proposals, because that's the only way you're truly going to be able to know. Oh, one more story. I'm sorry. I like telling stories. So here's one more story for you. And this is a real true story. It happened to one of my townhome communities. Unfortunately, it happened. I wasn't involved in it until late afterwards. It really wasn't a whole lot I could do. It was a townhome community. The association was replacing roofs. The board decided to go with the least expensive proposal. I don't really think they reviewed everything. And it was supposed to be a replacement of all roofs in the community. So this contractor replaced the roofs, and when all was said and done, the association said, well, wait a minute, you didn't replace the roof of the clubhouse. And the contractor said, well, that's not included. I didn't include the clubhouse. I just did all the residential buildings. And now if we have to pay this contractor to redo the roof on the clubhouse, it's actually going to cost us more money than if we just hired the more expensive contractor, because he included that in his bid. And so this association was livid that they were not getting their clubhouse re-roofed. And there really wasn't a whole lot we could do, because when we read through all the fine print in the contract, it specifically said these are the buildings that are going to be re-roofed. No other buildings are going to be re-roofed. So details matter. I'll move on. Not verifying insurance. I know contractors always assure us they're insured. And I also acknowledge that there are several big kind of contracting companies that we work with all the time. And so we know they're good for it. We know they're insured. We worked with them before. I'm not necessarily talking about those companies. I'm talking about companies that you've not worked with before, or companies you've not heard of before. And not verifying insurance by obtaining or by having them show you a certificate of insurance is very dangerous for associations. The primary concern with them not having insurance, if they're underinsured, is if they have employees who get injured on the job, then those employees can go after the Association for Workers' Comp. Colorado that's the kind of state we are. We have our workers' comp provisions in the statute basically allow a worker whose employer is underinsured to go after the party being benefited by the work. So that's the association. So that's something they can do, and I've seen it done before. And that's another reason why we tell associations you need to carry your own, workers' comp insurance, even if you don't have employees. But that's the danger if we can't verify that the contractor is adequately insured. The other issues are, well, if the contractor isn't adequately insured and they do something wrong, they cause property damage, they cause injuries to homeowners, whatever it is, that's a problem, because if we try to sue them, they are not going to have any funds available to make us whole. So it's almost like a useless endeavor, because the funding typically comes from the insurance. And if they don't have it, or they don't have enough coverage, you can't squeeze blood from a turnip. So it's important to make sure that our contractors are adequately insured. So this kind of flows from the insurance, and that is making sure they're licensed. Now, to the extent they have to be, of course. So I'm going to tell you a story now. This is another story, and it's actually happening right now in one of my communities. It's a condominium community, but it's kind of looks like a townhome community. Those, the tricky kind. Homeowner goes to association, says, hey, you need to repair the exterior of my unit. Association, they don't know any better. They say, no, it's your unit. It's your responsibility to repair this. So the homeowner goes and gets an attorney to represent her, and the attorney sends a demand to the association. The association then contacts us And we look at everything and we say, no, this really is your obligation, HOA. You need to do this. So now the association is looking for a contractor to do the work. Well, they find a contractor. I've not seen a copy of the contract with this contractor. I frankly am not sure if one exists. But the contractor starts doing the work. I receive an email from opposing counsel, and he's like, hey, I don't see that your client pulled a building permit. And a building permit is required for this type of work. I'm like, what? So I do my own kind of digging. Sure enough, the city requires a permit for this type of work. So I reach out, to the client. I say, hey, opposing counsel's pushing to get a permit. So they send a contractor to the city to get a permit. Well, guess what now? The city will not issue a permit unless the contractor is licensed through the city. Like, they don't care about their other credentials. They want to get them licensed through the city. I know what city does that. But this is what happens when we don't make sure, and so now this contractor, and it's kind of like a mom and pop shop. So they don't have a lot of resources. They're trying to figure out how to get licensed through the city so that a building permit can be pulled so that the work can be done. Meanwhile, opposing counsel is really pushing on this, saying, hey, if my client gets more like interior unit damage because you didn't fix the exterior and water's coming in, that's on you. And frankly, I think he's probably correct. So again, could this have been avoided if the association checked for a permit? Maybe, maybe not, but this is how things tend to kind of spiral out of control, where you think, a license is not the big deal, but it really can be. So to the extent that licenses are required, we really want to make sure our contractors are licensed. Okay, not having legal review the contract. We have whole classes on, kind of what your contract should have, and this one slide is not going to encompass all of that. But this is not Alina's attempt to drum up work. This is Alina telling you I've seen some pretty bad horror stories with associations and contractors where the contract was not reviewed. Again, if you have a contract that's like under $5,000, it might not be worth it to have it reviewed. I typically recommend contracts over $5,000 be reviewed, and I really, really, really strongly recommend any contract over $10,000 be submitted to legal. That's just not pocket change, and we don't want to take any chances. So just a few examples of the types of things we look for. This by no means is an exhaustive list of the types of things that your attorney is going to look to when they review the contract, but it's a few things. And I've been told before in classes by mostly it's board members saying, well, we don't really need attorneys to review it. You guys are just doing this so you can collect fees and blah, blah, blah. And then I went through kind of the things that we look for, and I saw this board member, her jaw gradually started dropping as we went through each one, because she had no clue. She didn't know. And then she was like, oh, crap. So this really will save associations money in the long run should something go wrong. So what do we look for? Well, we want to look for an indemnification provision, which basically says if contractor does something dumb, stupid, egregious, willful, and causes damage or harm to a person or property, and the association gets sued over it, then that contractor has to pay for the association's legal defense and for any damages that are awarded, et cetera, et cetera. So that's a pretty typical provision that you see in contracts. Usually it works both ways. Payment terms, that's kind of a big thing. I think there's very few times where I've reviewed a contract where I didn't have to edit the payment terms, because usually it's like 50% upfront, 50% substantial completion. And substantial completion isn't final completion. It isn't even full completion, the way they define it. And it basically leaves no area for associations, no wiggle room to be able to withhold money until final completion, to be able to, be able to walk through and make sure everything's done correctly before final payment. It really kind of puts the association at a disadvantage when it comes to payment, because we're almost always obligated to make the payment regardless of anything else. And that's a big deal, especially when you got a contract that's like $500,000 for a roof replacement. Change orders are big because I don't know if any of you have experienced this before, but comes a time when we hire a contractor, they quote us a price, they come in and they're like, oh, look, we found this, this, and this, and we didn't see that when we first looked at your property. So now the cost is going up, right? We need to do X, Y, and Z, and the cost is going to go up. Well, that's a change order. They're changing the terms of the contract. So we really want to ensure our contracts have provisions that, first of all, guarantee the price. Second of all, specifically say that the contractor is adequately inspected and they're not going to charge us more for things. And then a provision that says, if we are going to change the terms of the contract, that requires a written and signed change order, and any work performed by the contractor without a change order they're not going to be entitled to compensation for any additional work. That's a big deal. What happens if there's a breach? What happens if the contractor is doing shoddy work? Can we stop the work? Can we stop paying them? Can we cancel the contract? Can we kick them off the property? What are our rights? That's an important provision. Attorney fees, another important provision. And this is not for the benefit of the attorney. I know most folks, when they hear me say that, they're like, well, of course you're going to want attorney fees because that's for you. I'm like, no, I'm going to get paid regardless. What we want is for the prevailing party to be able to get its attorney fees awarded from the other party. So Colorado, I keep saying it's an interesting state. Well, it is. And so we don't have any automatic attorney fee provisions in statute that basically say if you have a contract dispute and you win, you can ask for your attorney's fees. We don't have that. And so the only way the prevailing party can ever request or get its attorney fees is if that right is set forth in the contract itself. If the contract is silent, you don't get attorney's fees. Everyone kind of pays their own, which in a lot of cases kind of defeats the purpose of even being able to enforce the terms of the contract, because attorney fees are expensive. And depending on how much the contract is for and how far it's going to go in the legal process, you could be looking at tens of thousands of dollars to litigate it, and maybe you're fighting over $10,000. It's just not going to be worth it. And so the attorney fees provision protects the association and the contractor, where if we have a lawsuit over a breach, whoever wins gets to ask for their legal fees. Attorneys get paid regardless, right? Right to withhold fees if the contract isn't being performed the way that it's supposed to, or you're doing something wrong, or there's a breach, or whatever is happening. We want the association to be able to withhold its fees. We want a provision that says, even if we pay you, contractor, that is not going to be deemed a release, or the fact that we're accepting the work, or the fact that, somehow you're protected from any claims just because we paid you. That's a good provision to have. Notice, when we have to send notice to the contractor and the contractor sends us notice, how's that going to happen? Where do they send it? How do they send it, right? Do we need actual receipt? Do we need certified mail? What do we need to effectuate notice? And then, of course, there's termination provisions where, for example, service contracts. So I'm just going to use management contracts. For example, your management contracts have a provision that say this contract, usually you have it, maybe terminated with or without cause upon X number of days, 30 days, 60 days, something like that. So that's a termination provision. And that's for service contracts, so where the service continued on indefinitely. So those types of provisions are really important because otherwise we don't really have termination rights. And then how do you take care of that, right? So these are very, very, very few of what we look for when we're reviewing contracts. And I unfortunately have seen firsthand associations that get into a fight, debate with their contractors where the attorney has not reviewed the contract before and there's absolutely no protection for the association. I just had this discussion with one of my communities. It's basically a contract that renews for 6 years every year. And there's nothing in there that allows early termination. There's nothing in there that allows termination for cause. And the association's screwed because it just renewed. And they missed that specific timeline within which they had to tell the vendor that they were not going to renew it. So now they're stuck for 6 more years. They weren't happy. All right. Okay, so remember earlier I was telling you how a bid is not a contract? Okay, this kind of falls right into that. When I see associations presented with a one-pager and a signature at the bottom, I get very, very nervous, especially if the board's already signed off on it. A red flag should automatically be going off in your heads if you are presented with a one-page agreement to sign. Now, and usually with a bid, I see a lot of one-page bids out there. And that's why I'm saying, don't ever sign the bid. It's not the contract. You actually need a contract that spells out like the things that we just talked about, plus some. So if you get a one-page contract, flags should be like exploding all over the place in your head, and you should be reaching out to the association's attorney and having them review it. Again, if it's like a $500 thing, I don't care. A $1,000 thing, I don't care. As the number increases, so does the risk, and you are going to need to have legal review it. In most cases, what happens is, or at least what I would do is, I would actually create a contract, and to the extent there's any work description in this one-pager, I would attach that as a scope of work, as an exhibit to the contract I just drafted. Some of you I've done that for, and you know how it works. But all these protections we just talked about, imagine trying to fit all of them into one page. Can't do it. I mean, unless you use microscopic print. So you're never going to be able to get adequate protections in a one-pager. Don't sign it. It's not a good thing. It's never going to be a good thing. Okay. You want me to tell you how I really feel? Don't sign it. Okay. All right. Another one. Using volunteers or paying residents. It's actually 2 different things. I combine them into one. So let's do each one separately. Let's do using volunteers. I see a lot of communities where they've got residents or whoever, owners who want to volunteer, trash pickup, tree trimming. I mean, you name it, I've seen it. And there's a problem with doing that. There's a risk. There's an inherent risk, because when you have volunteers, even though you're not paying them, there's still a liability exposure if they get injured while performing any kind of services for the association. The association, I mean, you may not be paying them, but they are performing things for you as the HOA. So if they get injured, there is a liability exposure there for the association. What we typically recommend is making sure any volunteers and all volunteers sign a volunteer waiver and release, which is basically a document that says, hey, I'm volunteering to do this. I understand the inherent risks and dangers. I understand the association isn't responsible for me. I will not go after the association, blah, 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 blah. But at the end of the day, even if you have one of these, it is not the end all be all. It will not protect you from all claims. So a homeowner who's volunteering could still bring a claim against the association even if they signed a volunteer release. So don't think that if you get one of these, you're safe and sound and nothing's ever going to happen. That's just not the case. Let's talk about paying residents. I think this has a lot of implications. If you are paying someone to do work for the association, they have to be one of two things. They have to be an employee or they have to be an independent contractor. There are no other options. If they are an employee, then they better be paid. You gotta have to take out the taxes that you need to take out for any employee. You're gonna have to give them a W-2 at the end of the year. So all that stuff that goes into employment you're gonna have to comply with that as an association. And most associations just aren't equipped to do that. So if you're paying a resident to do something, they're probably not gonna constitute an employee. But are they an independent contractor? Well, they might be. But the issue with the independent contractor is, remember we talked about how they need to be licensed, we need to make sure they're insured. Your residents aren't going to be insured as contractors if they're just, doing something, they're cleaning up the yard to get paid. They're trimming trees, they're cleaning snow, whatever it is. So we have exactly the same problem now. We have people performing work that we're actually paying to perform work. So if they get injured, they are entitled to workers' comp, because even though they may or may not be independent contractors, remember, even contractors who are underinsured can still request workers' comp from whoever benefits from their work. So there's a huge, huge kind of liability exposure there. And typically you're not entering into written agreements with them. So we don't have any recourse if the work sucks. If somebody gets hurt on the job, what happens? Well, the association has absolutely no protections in that case. And there is going to be a huge liability exposure, especially if the damages or the injury is bad. So as a general rule, we do not recommend ever paying residents to do anything unless they are truly a contractor and you can enter into a contract with them and they happen to be, they happen to specialize in whatever it is that they're doing. It's a bad idea. I don't recommend volunteers. I don't recommend paying residents. I don't recommend, paying Johnny down the street who's in high school, needs to earn some extra money, to go do stuff for the association. I know it's sometimes associations want to help people make some money. They want to save on costs, but ultimately what they're really doing is exposing the association to needless liability and a lot of potential damages. So I do not recommend that associations utilize this method for getting work done. Okay, next one, not asking about use of subcontractors. So a lot of contractors, when we contract for work, they retain subcontractors to perform, parts of the labor, especially when you're doing like general contract work. Why do we care? Right? Why do we care if they use subcontractors? Well, I've had situations before where associations, they didn't really delve into this, and the contractor used a sub that the association had actually used before as a contractor, and they hated this company, absolutely hated it, didn't want anything to do with it. And all of a sudden, this company is out on their property doing work. And the association absolutely had nothing it could do about it. It reached out to the contractor. It said, what are you doing? We don't like this contractor with a sub. And they said, well, sorry, we can use whoever we want to use, and we're going to. So it does happen sometimes. So we like to see something in the contract, or at least you want to have something in writing that talks about, are they going to use subcontractors? Should we have them, disclose who the subcontractors are? And is the association, does it have an opportunity to review those and veto any of them? I've seen that kind of language where the association, contractor discloses all the subs, association has 5 days to review, and if it objects, it has to give written notice of its objection within 5 days or something like that, and then the contractor won't use that sub. I think that's an advisable thing to have because, again, you never know who the subcontractors are. Is the contractor responsible for the actions of the subcontractor? A lot of times the contractors are going to say, no, they're independent. We have nothing to do with them. We just called them in to do the electrical work. We just called them in to do the painting. And we don't have any obligation. If they screw up, that's between you, HOA, and them, even though we never contracted with them. So we do want to make sure that the contractor has a legal responsibility to oversee and is also responsible for any damages or anything else that the sub does. And then kind of on a final note with that, lien waivers. So Colorado's mechanics lien law provides that if a subcontractor or a material supplier is not paid by the HOA when they do the work, or not by the HOA, sorry, by the contractor. The contractor is supposed to get the money from the HOA, and then they pay their subs, they pay the material suppliers, and then they keep what's left. And so to the extent that a contractor fails to do that, and a subcontractor or material supplier is not paid, then that entity or that individual can record a mechanics lien against any property, again, benefited by the work. So that includes common area, but that also includes individual units. Had an association, this was a few years back, they had, I can't remember what but it was like a whole bunch of exterior building work. Association paid the contractor when all was said and done. Contractor took the money and ran away, and none of the subs got paid, none of the material suppliers got paid. Oh my God, what a mess that was. They all recorded liens. Homeowners were not happy, association was not happy. It was a horrible, horrible mess to clean up. Ultimately, the association got screwed because it had to make payments, double payments on the work. So how do we protect associations against that? Well, we definitely want to make sure we have language in the contract that talks about lien waivers. And what it should say is, at a minimum, first of all, you shouldn't have final payment due until full and final completion of the project, which means we've looked at it, we've had it evaluated, we've gone through punch list items. Yes, I want to go through punch list items as part of that. And we have now accepted it. Part of that final payment, before you make the final payment, we need to have in our hands lien waivers from all the subcontractors and all the material suppliers. And what lien waivers are is they say we acknowledge we got paid, we acknowledge that we will not, and we do not have a legal right to recording mechanics liens against any properties, and we will not record mechanics liens against any properties. That's what a lien waiver is, and that's what we want in our hands before we issue any final payment. What a lot of contractors do is they will get you what they call a lien waiver from a subcontractor, but here's what it says. It says, what we agree not to record any mechanics liens against the properties once we get paid. So they haven't gotten paid yet. And what they're essentially saying is we're not going to record any mechanics liens once we get paid. Well, that's the law anyway. They're not saying anything that isn't legally required to begin with. What we really need are papers that say we have gotten paid. We waive any rights we have to record any mechanics lien against any of the properties. That's what we need. That's the only thing that's going to protect the association. All right. So now we kind of are getting into those, I call them soft topics, because they're not as much legal as they are, practical. And I know you guys are truly, the experts in this, and the qualifications and references of your contractors. So for contractors that your communities work with that you don't know or you've never worked with, it's really important to review their qualifications and to check their references to make sure that that they can do the work that they're bidding to do, to see if they've worked with HOAs before, to see what kind of reviews they've had from other, folks who hired them, to see how long they've been in business. If they just came into existence last year, do we really want to take a risk on that? I don't know. So I think it's an important thing to do if it's a contractor you're not familiar with. Obviously, our contractors that we work with all the time, I know you guys know they're qualified. I know they do good work. And I'm not talking about those people. I'm talking about the folks that we've never worked with, never heard of, or maybe folks that we think we may have heard something bad about. So those are all important things to check out. All right, last one. So the last one is not interviewing the contractor. As with the prior slide, I am really thinking about those contractors you've not ever worked with. Obviously, if you've worked with them, you know them, you've talked to them, you don't need to interview them again. Some boards will want to interview because they have not personally worked with a contractor. And even though the community manager says these are good, there's some boards out there that are going to say we still want to talk to them. So a contractor you've never met before, contractor you've never worked with, I think it's good to interview them, whether you're doing it like, in person, face to face, or you're doing it through a Zoom meeting. It's kind of like, is it clicking? Do you feel comfortable with them, or is there some reservations that you're having? Sometimes people seem good on paper, but when you actually are face to face with them, all of a sudden you just get really bad vibes. I think those are important things to pay attention to. And it gives you an opportunity to ask them questions and see how they respond right there on the spot. So interviewing your contractors is definitely something that's recommended if you've not met the contractor before or worked with a contractor before. Haha, another comedic break. All right. Ta-da! So let's look at some of your questions. I see a few of them, so I am just going to look. Let's see what we got here. Let's see. All right, here we go. My HOA repeatedly uses a preferred vendor instead of getting more than one bid. Is this an acceptable practice? Well, if you're asking if it's illegal, if it's lawful, it is lawful. I think it depends, again, on what you're using them to do. Is it like a $500 project here and there, or is it lots and lots of $1,000 projects? Because if it's like a really expensive project that they're doing, and you keep hiring them for really expensive projects, a homeowner could argue the board is not conducting its due diligence by looking to see if there's anything else out there, right? To see if there's someone better. Now, I also understand that if you've used them before and they do a great job for you, why would you want to look anywhere else, right? That does come into play. And so I think it's a balance of things. If you have a preferred contractor you're working with for certain things, I think usually that's going to be okay. But if we're starting to get into projects that are getting up there in the dollars, it probably would be a good layer of protection for the board to have more than one bid to look at. They can still go with this preferred vendor, but at least they can compare and see what else is out there. All right. Next question. What if your town does not require contractors to be licensed, but maybe the county does? Yeah, that's kind of the tricky thing when we're talking about checking licenses. For most professionals, licenses are governed through DORA. Plumbers, electricians, those types of professions are governed through DORA. And so one way to check, if they're licensed is you could just go on Dora and do a search. It becomes a little more difficult when we start looking at the individual counties, the individual cities, the individual towns, whatever it is. And so, sometimes we're not going to catch everything. And sometimes we're going to miss it, like we did with this one story I told you about with the contractor who had to get licensed through the town. I don't know that that's something the association would have known to look for. And so you can really only do the best you can with what you got. So I would say, you want to check with Dora if it's a kind of a profession that requires licensing. Dora also has a list of professions that require licensing. So if you're not sure, you can definitely just go and scroll and find that. If they need to be licensed with a particular city or a particular county, then ideally you want to make sure that they have that license or that they're going to obtain it like before they start doing it. Do you have a volunteer agreement to share it with? So I don't have anything like right now, right this second. We used to, I think a long time ago on our website, if you want to look, I think we might have had a generic one up there, just like as an example. I don't know if it's still there, but if you go on our website, you can just type search for volunteer waiver or something like that and see what you come up with. It might still be there. All right, next. Let's see. Sorry, I just scrolled too far. IHOA thinks they can use a general conditions contract attached to bid in lieu of attorney review. They won't budge on this. Well, I mean, you can lead a horse to water, right? If they're not going to want to spend the money at some point, it will come back and bite them. And maybe then they'll think differently. But all we can do is advise our clients as to what's recommended. And if they choose not to follow that advice, that's their choice. Can you touch base on the independent contractor forms or rejection of workers' comp for contractors? I'm okay, so I apologize, but I'm not entirely sure what forms you refer to. If you're talking about an independent contractor agreement, or are you talking about like K-1 tax forms? What are we talking about? If it's the agreement, it's kind of like what we already talked about during the session. It's got to have all that stuff in there, all those protections in there. And workers' comp claim, that's part of, you want to have something in the contract that talks about them being adequately insured, them providing us with proof of insurance before they ever start the work, that type of a thing. If I didn't answer your question, I'm just being confusing, please just send another follow-up email. I apologize. I heard liquidated damages usually aren't worth enforcing. RHOA didn't follow up on a six-figure claim from a delayed contractor. How can timelines be held true for large project if not liquidated damages? So liquidated damages may be enforceable, and we see that a lot more from the contractor side than the association side. And they may be enforceable. The problem is it really all depends on the facts. So if you're talking about, if the contractor will finish the work by this day, if it is not done by this day, the contractor shall pay the association $100 per day as liquidated damages until the work is done. That kind of sounds like what you're talking about. Well, if the work wasn't done through no fault of the contractor, or if the work wasn't done because of some natural disaster, because of something the association did, then yeah, you're probably not going to be able to collect in that liquidated damages amount. But if the contractor is just dilly-dallying and we can show that they truly are breaching the contract, you might be able to do it. So it's not a black and white. This is really going to depend on a lot of different things that are happening in what the situation itself. Is it okay to give volunteers gift cards to recognize their work? I mean, you can. It is a form of compensation. It could, so you want to be careful with, what you're giving them and when if you're giving it to them right after, they perform the work, or if like at the end of the year, we have a thank you volunteers event where we give it to them then. It might make a difference in how it's viewed, because we want to make it look like it's not a payment. It's not compensation for the work you did. So the more we can separate the timing of when we give it to them and when they perform the work, I think the better it'll be, but it could still be viewed as compensation. So it could still prove to be an issue. Board approved $200,000 project without looking at any bids that owners brought to the table. Is there liability to the board? Well, I think the liability might depend on if the contractor that they chose did a really shoddy job, or, I mean, homeowners can sue and they can say, look, you didn't perform your due diligence and you could have picked a better contractor, but they'd have to prove all that. So I think the bigger question is, did the board breach its fiduciary duty by not looking at, by not getting educated before making its decision? Maybe the decision wasn't wrong, but they weren't educated, and so they did not perform their due diligence. And is that in and of itself a breach of their fiduciary duty? It's really hard to bring these kinds of claims against the association if the homeowners can't show some kind of damages. So I would suspect there's probably not a whole lot of liability exposure there unless the contractor really screws something up. If you supply volunteers with equipment to do work, do we expose ourselves to liability? Yeah, yeah, especially if the equipment's faulty and they get hurt while using the equipment. But a lot of associations supply their volunteers with the tools and the equipment. So you better make sure that those are in good shape. But the exposure is the same. They could, whether they get hurt using their equipment or your equipment, you're still exposed to liability as an association. Do you think the building insurance companies drop coverage if a builder is not licensed or able to show expertise and capability to do a large project? It is so hard to predict anything that insurance is doing these days. I know you guys have all seen the craziness going on. They're leaving the market. They're dropping associations. At this point, I would assume, retaining a contractor who's not insured could easily be used against an association and they could be dropped coverage. So yeah, I would assume that to be the case. Obviously, every insurance company is a little different, but it's crazy out there. You guys know that. Let's see. I know we're almost done. So we're going to get out here on time. Let's see. We have events such as pool cleanup. Try to get my mouse to work. Such as pool cleanup. Or set up for the season, and we have members of the community helping. What is the liability risk of this? Are we better off getting a contractor, or is an HOA board doing it? Same events such as parties, etc. What is the liability? So real quick, you're always better off having a contractor do it for as far as liability exposure goes, because anytime you've got, volunteers, this is exactly the same thing we talked about. If you've got somebody, members coming in the community and helping clean up, it's the same liability exposure we already talked about. So yes, you are exposing yourself to liability. Yes, you should have them sign volunteer waivers, but ultimately that's not going to fully protect you. I think you would be better off getting a contractor. Yes. Okay. So let's see. Last question. If following an RFP process, can we share bids with committee members or all members without much reservation for members to scoring the RFP. Are there any liability risks being too free with the information? Be careful. So under Kiowa, we are not required to share bids. We're only required to share signed contracts with homeowners. The concern with sharing bids is there's a lot of times stuff in there that the contractor considers to be private, and they don't want to disclose to other contractors so that they can then, have competitive bids. We really don't want to share the bids with anyone outside the board, or if you have a committee involved in making, a recommendation on a contractor. Outside of that, I would not recommend sharing copies of bids. Okay, it's 1 o'clock, and I know there's like 2 more questions. Please, you have my emails up here. Please just email me directly, and I'll be happy to try and get those questions answered for you. So I just want to respect everyone's time. Thank you so much for joining us today. We are